Chapter 59. Violation of Liquor Laws. Section 746. Generally, at common law a tippling house was indictable as a nuisance, and there are some statutes which make the same an offence. This offence was sufficiently discussed in the chapter on disorderly house. From early English times the sale of intoxicating liquor has been regulated by statute. There is no other business or occupation which is so much regulated by statute today as the selling of intoxicating liquor, and the statutes are so various in form that no attempt will be made here to treat the subject more than generally. The statutes regulating such sale are an exercise of the police power of the state on the theory that the free sale and use of intoxicants is detrimental to the public. There is also the fact that the licensing of the sale of liquors forms a considerable source of revenue to the state, and for this reason also the state is interested in protecting its revenues, and the rights of those who have purchased a license to sell liquors. Section 747. Liquor Statutes and Federal Constitution. Statutes regulating the sale of liquor when tested have been held not to violate the federal constitution, for they do not impair the privileges and immunities of citizens of the United States by regulating or taking away the right to sell liquors, nor deny to citizens of another state privileges and immunities granted to its own citizens when the issue of licenses is restricted to citizens of a state, and the diminution in value of property devoted to the manufacture and sale of liquor is neither depriving persons of property without due process of law, nor taking property for public use without compensation, since property rights are subject to the police power, and there is nothing taken for public use. Nor do statutes providing for the abating in an equity trial of keeping liquor for unlawful sale, or selling it unlawfully, deny due process of law. However, it seems that statutes discriminating in favor of liquor made in the state are unconstitutional. So is a state statute restricting transportation into a state, and regulations as to the sale of liquor do not apply to their sale in the state as articles of interstate commerce in the original package in which they were shipped. After the decision as to sales in the original package was made, the Wilson Act was passed by Congress. This act made liquors brought into the state subject to the state regulations to the same extent as if produced in the state, even if sold in the original package. Even under this act a state could not prohibit importation of liquor into the state. Section 748. Liquor Statutes and State Constitutions. Usually the liquor statutes have been held valid under state constitutions, as not violating any rights secured thereunder, and it is held that they do not take property without due process of law or without compensation, and that equitable abatement does not deny the right to jury trial, that, as a license is not a contract, the imposing of additional restrictions on, or prohibition of the sale, does not impair the obligation of contracts as to sellers already licensed, that laws prohibiting sales within a certain distance from a church or city are not invalid as being local laws, and local option laws are valid, that the imposition of licenses is not taxation in such a sense that it must be uniform in all localities, or at the same rate as other businesses are licensed, that the requirement that the seller shall be of good moral character, etc., is constitutional, that a prohibitory law is valid, also a law vesting the sale in a public agent and forbidding sales by private parties. Statutes relative to evidence and procedure which place burdens on the defendant heavier than in other prosecutions are valid if they leave fair opportunity for defense. Section 749. Construction of Liquor Statutes. Various questions of construction arise when by a subsequent statute a method of dealing with intoxicating liquor is adopted which conflicts with the former method. Conflicts also exist between the power of the state and of cities to regulate. Generally, it may be said that regulations not inconsistent with each other will be enforced though not part of the same system. But if the systems are distinct and exclusive there can be prosecution under only one. If the statute granting power to cities to regulate gives the city exclusive power then the state laws will not be enforced in the city. If the city ordinance authorizes sales, but a sale not authorized by ordinance may be punishable under the state law, provisions of an ordinance in violation of authority are void. If the systems are changed, as by the adoption of local option, there may be prosecutions after the taking effect of the new law for violations of the general statute committed prior thereto. If the general statute is merely suspended in operation, and not repealed, But if the new law repeals the old by implication and there is no saving clause, there can be no prosecution for former violations. Generally speaking, the power granted to a city is not considered exclusive, but subordinate to the general laws of the state, although a city may make additional restrictions. In such a case the seller must comply with both state and city laws. The same act may be prosecuted under both the state law and the ordinances of a city. Section 750. License. The most common regulation of the sale of intoxicating liquor is probably the license system. A license is permission granted by some competent authority to do an act which, without such permission, would be illegal. Under the license system, liquor can only be sold by those having legal license. Such license must be issued by proper authority, contain all items required by statute, and the proper preliminaries must have been complied with. If the requirements of the statute are not substantially complied with, the sales under the license will be illegal. Usually a bond condition that the licensee will not violate the provisions of the statute is required. Sales cannot be made under the license until it is in fact issued, although an order for the license has been issued. Conditions annexed to the license privilege must be complied with strictly. A license to sell for certain specified purposes impliedly prohibits sales for any other purpose. The issuance of a license cannot validate previous sales, even if it is dated back. License granted by a tribunal having authority can be attacked only by appeal, and if the issuing tribunal is reversed, sales made under the license before that time are unlawful. But the jurisdiction of the issuing tribunal may be inquired into collaterally, and the license is void if it is shown that the necessary preliminary steps were omitted. A license granted contrary to state law by a city will not bar criminal prosecution but may stop the city from recovering the penalty. Statutes often provide for the revocation of licenses for illegal sales. Privilege conferred by a license is personal and not assignable, so the executor or administrator of a deceased licensee cannot carry on the business under the license, and one who purchases a saloon keeper's business cannot sell under the license of the former owner. But the licensee may sell through an agent, and the principal's license protects the agent, although the agent is liable if he makes sales exceeding his principal's authority. If the principal removes from the state, the agent is not protected by the license, an exception being made to this rule where the principal was absent in the war. License to one member of a partnership gives no right to the other members to sell liquor. Usually the issuing tribunal is given some discretion in issuing licenses, from which discretion there is no appeal, but an arbitrary refusal, without a reason, to grant a license may be ground for the issuance of a writ of mandamus to compel its granting. If a license is issued without authority, quo warranto will lie. But a wrongful refusal to grant license is not a defense for selling without a license. Neither is impossibility to obtain a license a defense. Sale without license is punishable as such. License to sell for certain purposes is no defense to sales made for other purposes. Usually a license describes the place where the liquor shall be sold under it, and sales elsewhere are criminal. Two buildings are considered not the same place even though on the same lot or connected. Neither are two rooms in the same building one place, but sales may be made under one license in two rooms in the same building connected by doors or archways. Some courts hold that the prosecution must prove that the sale was made without license. It is more commonly held that the defendant should prove that he is licensed. The indictment should negative the license. Section 751. What are intoxicating liquors? Some statutes specify intoxicating liquors by name. The only question then is one of fact, as to whether a named kind of liquor was sold. Others define intoxicating liquors as those containing a certain percent of alcohol. In both these it is immaterial whether the liquor is actually intoxicating, but when the liquor which was sold is not particularly named in the statute, which uses general terms such as intoxicating, spirituous, vinous, malt, fermented and so on. Some decisions hold that it is a question of fact for the jury whether the liquor sold is within the statute. Other cases hold that the court takes judicial notice that whiskey, ale, wine, lager beer and similar liquors are intoxicating, and the only question for the jury is whether the liquor is one of these kinds. A liquor commonly used as a beverage which contains enough alcohol to intoxicate if used in large quantities is an intoxicating liquor. It has been held unnecessary to give specific proof to the jury that the following liquors were intoxicating: whiskey, alcohol, gin, beer, cordial and whiskey or brandy mixed with water, also mixed liquors of these classes. It is generally held that there must be proof of the intoxicating qualities of wine, cider, or bitter. If the sale of a certain kind of liquor, as malt liquor, is prohibited, the sale of non-intoxicating malt liquor falls within the prohibition. Section 752. What is a sale? The charge and proof of the illegal sale must, of course, vary with the provisions of the statute under which the indictment is laid. Some statutes prohibit selling to a minor or a drunkard, in which case the chief element of proof is as to the vendee. Others prohibit sales in quantities smaller than a quart, sales to be drunk on the premises, sales, before or after certain hours, sales on holidays, in each of which cases the essential elements to be proved are different. There is also the general offence of selling without license. Sales on credit fall within the statutory prohibition. A mere agreement to sell, not completed by delivery, is not punishable. It is a sale where the liquor is left for purchasers to find it and the money left in the same place, or where a drink is given with a meal, on with the admission fee to an amusement place, and a valuable consideration is paid. Barter or exchange is not considered a sale, nor is the distributing of drinks by clubs to members so considered by some courts, though others hold the contrary. The giving away of liquor is not a sale, though in some states the giving or furnishing liquor to another is prohibited, and some decisions hold a loan of liquor punishable, while others hold that it is not. Section 753. Sale or purchase by agent or servant. The keeper of any place is liable for an unlawful sale of liquor made by his employee in the course of his business. It is so held by many courts even where the sale is made without the master's knowledge or in violation of his order. Other courts, though the sale was made in the scope of the servant's employment, do not hold the master unless he expressly authorized the sale. The one set of decisions holds the illegal sale a police wrong, punishable regardless of intent. The others apply the general principle of criminal law, that one is not criminally liable for unauthorized acts of a servant or agent. In any case, a principal who neither expressly nor impliedly authorized the sale cannot be convicted. One may be convicted because of sales made by his partner, or his wife. The agent or servant who makes the unlawful sale is usually held liable, whether his principal is liable or not. One who has no interest in the sale but merely procures it for another, as an agent, servant or friend, is not liable as a seller. However, one who secures whiskey for another on a prescription which he procured for his own use is guilty of a sale, and a sale to a minor who does not disclose that he is buying as another's agent, is a violation of law by the seller. Section 754. Sale for medical use. The greater number of liquor statutes except from penalty sales by a druggist for medical use upon a physician's prescription, or sales by a physician for such use. The requirements of the statutory exception must be complied with, in order to assert it as a defense. If the statute makes no such exception, sale for medical use is no defense, unless, perhaps, in case of necessity. Where a physician's prescription is used as a mere subterfuge in order to obtain intoxicating liquor, it is no defense. The furnishing of liquor by a physician to a patient for medical use is not a sale. A sale to a minor for medical use upon a prescription is not an illegal sale to a minor. Section 755. Intent and knowledge. The general rule is, that lack of knowledge by the seller that the liquor is of a kind the sale of which is prohibited, or that the vendee was one of a class to whom sales are prohibited, as a minor or drunkard, is not a defense to the illegal sale. Criminal intent or guilty knowledge is not an essential element of the offense. It is not the sale, not the intention which accompanies it, which constitutes the offense. This rule obtains also where the prosecution is for violating a local option law. But the question of good faith enters into every sale of alcohol by a druggist, notwithstanding the formal sufficiency of his record. There are some cases which take the contrary view and hold that an honest mistake of fact where due care was used, is a defense. Section 756. Keeping intoxicating liquor for sale. Some statutes provide a penalty for keeping intoxicating liquor for sale. This offense is strictly statutory and the principal element is the intent to sell, so that without evidence from which such intent can be inferred, a conviction would be improper. Section 757. The Wilson Act. The Webb Kenyon Act, the Reed Amendment, the Wilson Act of 1890, 26 Stat. 313, ch. 728, provides that intoxicating liquors transported into any state or territory, or remaining therein for use, consumption, sale or storage, shall be subject on the arrival therein to the operation of the laws of the state or territory enacted in the exercise of the police power. The Webb Kenyon Act of 1913, 37 Stat. 699, ch. 90, prohibits the shipment and transportation of intoxicating liquor from one state into another state when such liquor is intended to be received, possessed, sold or used in violation of the laws of such state. The Reed Amendment, which is a part of Section 5 of the Post Office Appropriation Act of 1917, ch. 162, 39 Stat. 1058, 1069, goes farther than either of the two preceding acts. It provides, among other things, that whoever shall order, purchase, or cause intoxicating liquors to be transported in interstate commerce, except for scientific, sacramental, medicinal and mechanical purposes, into any state or territory the laws of which state or territory prohibit the manufacture or sale therein of intoxicating liquors for beverage purposes shall be punished as aforesaid, provided, that nothing herein shall authorize the shipment of liquor into any state contrary to the laws of such state. While the Wilson Act of 1890 permits state laws to operate on interstate shipments of intoxicating liquors after termination of transportation to the consignee, and the Webb Kenyon Act of 1913 prohibits interstate transportation of intoxicating liquors into a state to be dealt with therein in violation of the laws of that state, it should not be forgotten that the interstate transportation of intoxicating liquors still remains within the sole jurisdiction of Congress. By virtue of the Wilson Act and the remedial authority thereby conferred by Congress upon the states to regulate sales of liquor after arrival in the state and before sale in the original packages, a state has power to prevent solicitation of orders for intoxicating liquors to be shipped from other states. Speaking generally, however, the states are without power to directly burden an interstate shipment until after its arrival and delivery and sale in the original package. And this rule applies to the transportation of intoxicating liquors as well as to other commodities. The Wilson Act, however, modifies this rule as to shipments of intoxicating liquors so as to bring them under state control after delivery, but before sale, in the original package. The Wilson Act expressly provides that intoxicating liquors coming into a state shall be as completely under the control of the state as though manufactured therein. Hence the owner of intoxicating liquors in one state may not, under the Commerce Clause of the Federal Constitution, go himself or send his agent into another state and, in defiance of its laws, carry on the business of soliciting proposals for the purchase of such liquors. But a state may not forbid a resident therein from ordering for his own use intoxicating liquors from another state. The power to make interstate commerce shipments c. 0d is incidental to the right to make the shipment, and an attempt by a state to prohibit contracts to that effect or prevent fulfillment thereof is, as a burden upon, and an interference with, interstate commerce, repugnant to the federal constitution. Hence a state statute which imposes special licenses on express companies maintaining offices for c.o.d. shipments of intoxicating liquors is an unconstitutional burden on, and interference with, interstate commerce. The Webb Kenyon Act is a legitimate exertion of the power of Congress to regulate commerce, and is not repugnant to the Due Process Clause of the Fifth Amendment. This Act, which is entitled an Act divesting intoxicating liquors of their interstate character in certain cases, subjects interstate shipments of intoxicating liquors to state legislation. Hence a state law which requires carriers to keep records of such shipments, open for the inspection of any officer or citizen, is valid, notwithstanding the prohibition of Section 15 of the Act to Regulate Commerce, as amended, June 18, 1910, against the divulging of information by interstate carriers, and the power of a state under the Webb-Kenyon Act to forbid shipment into its territory of intoxicating liquors from other states includes the lesser power to prescribe by law the conditions under which such shipments may be allowed. The purpose of Congress in enacting this statute was not to prohibit all interstate shipments or transportation of intoxicating liquors into so-called dry territory, but to render the prohibitory provisions of the statute operative whenever, and only when, the liquors are to be dealt with in violation of the law of the state into which it is shipped. The test of interstate commerce is importation into one state from another. The transportation of one's goods from state to state is interstate commerce, and, as such, subject to the regulatory power of Congress. The transportation of prohibited articles upon the person of one being carried in interstate commerce is within the well-established meaning of the words interstate commerce. Section 758. Case of United States v. Hill. Decided Jan. 13, 1919. In this case the indictment charged that the defendant, Dan Hill, on November 20, 1917, being in the state of Kentucky, there intended to go and be carried by means of a common carrier, engaged in interstate commerce, from the state of Kentucky into the state of West Virginia, and intended to carry upon his person, as a beverage for his personal use, a quantity of intoxicating liquor, to wit, 1 quart thereof, into the state of West Virginia, and did in the state of Kentucky purchase and procure a quantity of intoxicating liquor, to wit, 1 quart thereof, contained in bottles, and did then and aboard a certain trolley car, being operated by a common carrier corporation engaged in interstate commerce, and by means thereof, did cause himself and the said intoxicating liquor, then upon his person, to be carried and transported in interstate commerce into the state of West Virginia. It also charged that said Hill violated the Act of Congress approved March 3d, 1917, commonly known as the Reed Amendment, by thus carrying in interstate commerce from Kentucky into West Virginia a quantity of intoxicating liquor as a beverage for his personal use, the manufacture and sale of intoxicating liquors for beverage purposes being then prohibited by the laws of the state of West Virginia, and further, that the intoxicating liquor was not ordered, purchased, or caused to be transported for scientific, sacramental, medicinal or mechanical purposes. The indictment was filed in the District Court of the United States for the Southern District of West Virginia, and the court sustained a demurrer and motion to quash the indictment on the ground that the phrase transported in interstate commerce, as used in the Act, was intended to mean and apply only to liquor transported for commercial purposes. This conclusion was reached from a construction of the Act when read in the light of other legislation, especially the Wilson Act of 1890 and the Webb-Kenyon Act of 1913. Under the Criminal Appeals Act, by writ of verre the case was brought before the United States Supreme Court to be reviewed, and this court decided that the United States District Court gave to the Reed Amendment too narrow a construction, and reversed the judgment of the latter court. In the opinion in this case the United States Supreme Court says, in view of the authority of Congress over the subject matter, and the enactment of previous legislation embodied in the Wilson and Webb-Kenyon laws, we have no question that Congress enacted this statute, the Reed Amendment, because of its belief that in states prohibiting the sale and manufacture of intoxicating liquors for beverage purposes the facilities of interstate commerce should be denied to the introduction of intoxicants by means of interstate commerce, except for the limited purposes permitted in the statute which have nothing to do with liquor when used as a beverage. That the state saw fit to permit the introduction of liquor for personal use in limited quantity in no wise interferes with the authority of Congress, acting under its plenary power over interstate commerce, to make the prohibition against interstate shipment contained in this Act. It may exert its authority, as in the Wilson and Webb-Kenyon Acts, having in view the laws of the state, but it has a power of its own, which in this instance it has exerted in accordance with its view of public policy. When Congress exerts its authority in a matter within its control, state laws must give way in view of the regulation of the subject matter by the superior power conferred by the Constitution. Section 759. The 18th Amendment to the Federal Constitution. In December, 1917, Congress passed a resolution submitting the text of the proposed 18th Amendment to the Federal Constitution to the state legislatures for their approval, and on January 16, 1919, the necessary 3/4 of the states had ratified the amendment. It reads as follows: After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territory subject to the jurisdiction thereof, for beverage purposes, is hereby prohibited. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress. Section 760. The bone-dry law of the state of Kansas, the most drastic prohibitory intoxicating liquor law in force in the United States at present, May 1, 1919, is what is known as the bone-dry law of the state of Kansas. This statute, which became effective February 14, 1917, provides, among other things, as follows: It shall be unlawful for any person to keep or have in his possession for personal use or otherwise, any intoxicating liquors, or permit another to have or keep or use intoxicating liquors on any premises owned or controlled by him, or to give away or furnish intoxicating liquors to another, except druggists or registered pharmacists as hereinafter provided. It shall be unlawful for any common carrier, firm or corporation or any other person for hire or without hire to bring or carry into this state, or carry from one place to another within this state, intoxicating liquors for another or for itself or himself, even when intended for personal use, and it shall be unlawful for any common carrier, its agent or employee to deliver any intoxicating liquors that may be in its possession to any person for any purpose whatsoever. It shall be unlawful for any person in this state to receive, directly or indirectly, intoxicating liquor from a common carrier or other carrier or person, and it shall also be unlawful for any person in this state to possess intoxicating liquors received directly or indirectly from a common carrier, other carrier or person. This section will apply to such liquors intended for personal use as well otherwise and to interstate as well as intrastate carriage. Penalties are expressly provided for violations of any of the aforesaid provisions. The Act also expressly excepts from its operation certain transactions by certain persons under certain circumstances. Thus the Act does not prevent any regularly ordained minister or regular priest of any church from receiving or possessing wine for communion purposes, nor prohibit and common carrier from receiving such wine for shipment and delivery to such regularly ordained minister or priest for such communion purposes. Nor does the Act, under certain circumstances, apply to druggists, or regularly established hospitals, or manufacturers whose products require a certain amount of alcohol for medicinal, mechanical or scientific purposes. The Act also provides that it shall be considered as supplemental to laws in force relating to intoxicating liquors, and furthermore, if for any reason any part of the Act shall be held void, such holding shall not invalidate any other portion of the Act.